Hello and welcome to Byju's Exam Prep IAS. Let's get started and look into our daily quiz. Let's look into the first question. The living root bridges, which are like a suspension bridge formed with living plant roots by tree shaping, is seen in the state of Kerala, Odisha, Meghalaya, Chhattisgarh. The answer to this is Meghalaya. Why have we taken this practice question? Because this article on the Hindu makes a reference to the living root bridge. The living root bridge is locally called as Jinkiangjiri. This happens to be a suspension bridge as shown in this image, which is formed by the living plant roots by the tree shaping. They are alive, they continue to grow, and over a period of time they would also gain strength as well. They are primarily used for crossing of rivers and streams as shown in this image. They are handmade from the aerial roots of the rubber fig trees, which are done by the Kasi as well as the Jaintia tribes, and they also showcase a symbiotic relationship between the people as well as the nature. So remember, this living root bridge is present in the state of Meghalaya, and now there is a proposal made by Zoological Survey of India along with the Chief Minister of Meghalaya, who recommend it to be part of the UNESCO World Heritage Site. As of now, it is not a UNESCO World Heritage Site, but they are requesting that it be accorded such a tag. Is what is this article all about? Now let's look into the next practice question. Which of the following are public authorities under the Right to Information Act? Election Commission, Indian Olympic Association, non-governmental organization, SEBI. The answer to this is 1, 2 and 4 only. Why have we taken this practice question? Because this article on the Hindu makes a reference to the public authority under the Right to Information Act. Let us try and understand what are these options. When we look into the definition clause of the right to information, which are the public authorities? Public authorities means any authority or body or institution of self-government established or constituted by or under the constitution. Since the Election Commission of India is constituted under the constitution, it happens to be a public body by any other law made by the parliament. Since SEBI is constituted by the law made by the parliament, it is also a public authority by any other law made by state legislature. The state legislature makes a law, and in this law there is a body which it specifies. Even that body or an institution will fall under the public authority by notification issued or order made by the appropriate government. In fact, if the government also makes a notification, that can also be called as a public authority. Added to this, if it is a body owned, controlled or substantially financed by the government of India or by the respective state governments, that can also be part of the public authority. The non-governmental organization can also be a public authority if it is substantially financed. So if you look into the second option, the Indian Olympic Association is substantially financed by the government of India, which is why it also becomes the public authority, but the non-governmental organization is not. Why? Because not all non-governmental organizations come under this particular bracket. Only those which are substantially financed will come under the public authority of the right to information, which is why the answer to this would be 1 to 4. Now the question is, what is the substantial financing? The right to information does not explain what is the substantial financing all about. This is basically interpreted by the court of law. This is not a uniform interpretation. It varies from case to case as well. Generally, you have the government of India giving some subsidies, or it is making some allotments, or it is making some finances to the non-governmental organization or to a specific body. That is what is called as substantial financing. So when it comes to the Indian Olympic Association, it was considered as a public authority because the central government happened to pay the travel expenses of the players and provided as much as 85% of their living expenses as well, which is why Indian Olympic Association is also part of public authority. Now let's look into the next practice question. Consider the following statements with respect to contempt of court. The Attorney General's consent is mandatory when a private citizen wants to initiate a case of contempt of court against a person. The Contempt of Courts Act 1971 has a limitation period of 2 years for bringing in action against an individual. Supreme Court has the power to initiate contempt cases on its own, independent of the motion brought before it by the AG or with the consent of the AG. Which of the above statements are correct? The answer to this is 1 and 3 only. Why have we taken this practice question? Because this article says AG gives not for contempt action against Narsingh Anand. Let us try and understand what are these options. We have something called as the Contempts Act of 1971. According to the Contempts Act, when it comes to the Supreme Court, we are speaking about the Supreme Court. Who has the power? The Supreme Court on its own motion on a suo motu basis would be able to initiate contempt action. One such example that we can speak of recently is about Prashant Bhushan case. So what happened? The Supreme Court on its own, on a suo motu basis where the AG had not given consent to it, but the Supreme Court on its own motion would be able to initiate the contempt proceedings. So the third statement is right. Apart from this, the Attorney General as well as the Solicitor General can also put it in front of the Supreme Court to initiate the contempt proceedings. The Attorney General realizes that there is an individual who is not complying by the orders of the Supreme Court. In such a case, the Attorney General has the power to ask the Court of Law to initiate contempt proceedings against an individual. Added to it, let's say for example, you decide that there is a particular person who is not listening to the orders of the Court of Law. You also realize that this particular person is not complying by the orders of the Supreme Court, or any other person in India feels that this has to be falling under the contempt proceedings of the Supreme Court of India. In such a case, every private individual would be able to make a suggestion, but such a suggestion will also require the consent of the Attorney General. So if there is a private individual who feels that contempt proceedings have to be initiated, such will have to be given mandatory consent by the Attorney General. Why is that the Attorney General has to give consent to a private citizen? Why is that the private citizen can't approach the Court of Law directly? That is because the Court of Law already has a crunch of time. If every person starts filing for the contempt proceedings to be initiated by the Supreme Court, it will waste a lot of time. So what will happen? The Attorney General will look into this particular case, sees if this is actually to be initiated in the Court of Law, and if he gives the consent, the Supreme Court will take it. So the Supreme Court will take cognizance of those cases where permission is granted by the Attorney General. So basically what the Attorney General does is he removes this particular case if it is frivolous in nature, if it is assumed to waste the Court of Law's time. In such a case, all those cases which are ignored, not given permission by the Attorney General, will not go in front of the Court of Law. But if it is given permission by the Attorney General, such is where criminal proceedings can be initiated against this particular person with respect to the contempt proceedings. When we look into the second statement, the Contempt of Courts Act 1971 has a limitation period not of 2 years but 1 year for bringing in action against an individual. Now let's look into the next practice question. Consider the following statements with respect to Saraswati River. It is a major Rigvedic river. It is part of Sapta Sindhu rivers mentioned in the Rigveda. The river had originated from Kapal Tirth in Himalayas in the west of Kailash. Which of the above statements are correct? The answer to this is 1, 2 and 3. Why have we taken this practice question? Because this article on the Hindu makes a reference of the Saraswati River. This is the Saraswati River. This is where historically it is assumed to be flowing. Now if you look into some of the facts about this particular river, this is a major Rigvedic river. It is part of the Sapta Sindhu rivers. Which are the Sapta Sindhu rivers? It includes Sindhu, Sudri, which is Sutlej, Vitasta, which is Jhelum, Vipasa, which is Beas, Askini, which is Chenab, as well as Purushni, which is nothing but Ravi. The text describes the Saraswati as a mighty and powerful river. The Rigveda says Saraswati flows between the Sutlej in the west and the Yamuna in the east and as flowing into the Samudra. Many modern scholars have also identified the Saraswati of Rigvedic times with the Ghaggar Hakra river system in northwestern India and the eastern Pakistan. So in the present situation, what we have is an attempt to revive the Saraswati River, where the Haryana government and Himachal Pradesh government have come together, entered into a memorandum of understanding where they are planning to construct a dam in Himachal Pradesh to revive this Saraswati River. Now let's look into the next practice question. The term M stripes is sometimes seen in the news in the context of captive breeding of wild fauna, maintenance of tiger reserves, indigenous satellite navigation system, security of national highways. The answer to this is maintenance of tiger reserves. Why have we taken this practice question? Because this article on the Hindu makes a reference to M stripes. What does M stripe stands for? It stands for Monitoring System for Tigers, Intensive Protection and Ecological Status. This is an application software based monitoring system launched across the Indian tiger reserves by the Indian government's National Tiger Conservation Authority. So the National Tiger Conservation Authority has come up with this particular software which is used across the Indian tiger reserves basically for the monitoring of the tigers. As part of the assignment, you have to put on the comment section where is the Bandipur and Nagarhole Tiger Reserve. It is located in which state? Now let's look into the fact of the day. The fact of the day for today's discussion is Indian Environment Service. What is the context? We have the Supreme Court of India which is hearing to one of the petitions. The petition is asking the Supreme Court of India to question the government of India whether it is planning to initiate one of the services called as the Indian Environment Service. So the Supreme Court is asking the government of India, dear government of India, are you planning to come up with a new all India service called as the Indian Environment Service? Now the question is, why is this come into picture? For which what we have to understand is a bit of a background. There was a high level committee that was constituted back in the year 2014 by the government of India. This particular committee was under the chairmanship of TSR Subramaniam. This was initiated by the Ministry of Environment, Forest and Climate Change. Why? So that they could review the entire environmental laws in the country. So we have the TSR Subramaniam committee which was appointed back in 2014 so that they could review all the environmental laws in the country. Initially, they were set to review the Environmental Protection Act of 1986, Forest Conservation Act of 1980, Wildlife Protection Act of 1972, the Water Prevention and Control of Pollution Act of 1974, the Air Prevention and Control of Pollution Act of 1981. Eventually, another law, Indian Forest Act of 1927, was also added into it. So basically, this was a committee which was appointed to review the environmental laws in India. The committee looked into all the environmental laws in India and came up with one of the important factual data. It said that when it comes to India, we have the strong environmental policy. We have number of laws. We have these laws which are able to prevent the deterioration of the environment. We have a beautiful legislative framework as well. But the problem is we have these laws, there is a legislative framework, but when it comes to the implementation, we have the weak implementation, says the TSR Subramaniam committee. Because we have the weak implementation, this has resulted in weak environmental governance, and as a result, you have the conservationists, environmentalists, judiciary which keep criticizing about the environmental laws in the country, says the TSR Subramaniam committee. So the TSR Subramaniam committee says that we have the laws, but when it comes to the implementation, it is very poor, says the TSR Subramaniam committee. In order to overcome this particular issue about the weak implementation, it comes up with the recommendation that we have to establish what is called as the Indian Environment Service. So according to this particular committee, an Indian Environment Service should be created. They should have experts in this particular All India service. They should be given a particular qualification, and all of this should be decided by the Ministry of Environment, Department of Personnel and Training and the UPSC. So a qualification will have to be described, and such people should be taken up for this All India Indian Environment Service, says the TSR Subramania committee. Now the question is, how is this All India Service created? We have Article 312 12 of the Indian Constitution. It speaks about all India services. If the Rajya Sabha, that is the Council of States, has declared by resolution, which is supported by not less than two-thirds of the members present and voting, then the Parliament may by law provide for the creation of one or more all India services common to the Union and the states. So what we require is the Rajya Sabha passing a resolution that it is important for the nation, for the interest of the country, and so they make a resolution which has to be passed with not less than two-thirds of the members present and voting. In such a case, the Parliament may create a law. In that law, they may create a new All India service. This is how an All India service is created. So the TSR Subramaniam Committee recommendation clearly says that we require an All India service in the form of Indian Environmental Service, where they will ensure that the laws and the legislative framework in India with respect to the environment is implemented as originally envisaged by the legislative body. Further, the TSR Subramaniam Committee also makes a recommendation for the establishment of Environment Reconstruction Fund. What is this fund all about? Let's say there is a private institution or there is an industrial body coming up with a project in one of the ecologically sensitive zone. So when this project is initiated, it will cause substantial damage to the environment. So the damage that it may cause, its financial issues should be calculated, and whenever the cost of the project is taken up, the same should be merged. It should be dovetailed with the cost of the project so that the cess or the duty from the project can be put up by the government, and ultimately the money that is taken up can be used for the development of the environment, is what is this Environment Reconstruction Fund. So these are some of the recommendations. So we have the Supreme Court of India, which is now asking the government of India that are you creating such an Indian environmental service, is what is the Supreme Court asking. Now we have to wait and watch if the government of India will initiate such an action for the establishment of a new All India service. So this is it for today. Thank you for watching. All the best.